This is a heavy industrial steam engine. In May 1853, inside the city flour mills in Gloucester, a massive crankshaft just like this one shattered. Joseph and Jonah Hadley, the mill's operators, watched their entire business grind to an absolute halt. Without that iron shaft, no flour could be milled, and no money could be made. They couldn't just buy replacement off a shelf. The broken iron shaft had to be hoisted onto a cart and shipped to a foundry in Greenwich. The engineers there required the exact broken pieces to serve as a physical model to cast a new one. The Hadleys hired the well-known carrier Pickford & Company, owned by Joseph Baxendale. Baxendale's clerk promised the shaft would be delivered the very next day, but through sheer negligence, the delivery was delayed for nearly a week. During those days of idle silence, the Hadleys lost £300 in profits, a massive sum at the time. The Hadleys sued the carrier to recoup that £300, raising a question that courts had never cleanly answered. When a shipping company breaks a delivery promise, are they on the hook for just the cost of the shipping delay, or are they responsible for the entire cascading financial ruin of the victim's business? A single broken piece of iron in a Gloucester mill forced the legal system to draw an exact, logical boundary around a broken promise. To understand the stakes, we have to look at the exploding Industrial Revolution. Businesses were now relying on fragile, interconnected global supply chains. Mills and factories were entirely dependent on third-party carriers to keep their machines running. But the legal system was still relying on unguided jury discretion. If you sued a carrier for a late delivery, a jury could award you almost anything based on emotion. There was no predictable framework for calculating damages. This created a massive imbalance of risk. If a shipping company moving a 5-shilling package could be held liable for a multi-thousand-pound business collapse, the fear of unpredictable lawsuits would stifle the entire transport industry. The courts recognized that commerce requires predictability. They used the Hadley dispute to build a judicial dam, containing the threat of limitless financial liability. Looking at the imposing facade of the Royal Courts of Justice, we can picture the setting for the Court of Exchequer. The Hadleys made a straightforward argument of cause and effect. The delay caused the mill to sit idle, therefore the carrier must pay for it. Baxendale's defense was equally logical. As mere movers, his company was never warned that the survival of the entire Gloucester mill depended exclusively on this one specific delivery. Baron Alderson delivered the ruling. He decided against the Hadleys. They could not recover their lost profits because those cascading damages were legally deemed remote. Alderson replaced a system of infinite blame with a system of reasonable foreseeability. He defined exactly what kinds of losses a business partner can be forced to pay for. Alderson's test starts with the ordinary course. A defaulting party is liable only for damages naturally flowing from the breach. Second, special circumstances. Extraordinary damages require both parties to explicitly discuss unique risks. Unwarned, Baxendale's outer ring of liability remained legally closed. The rule in Hadley acts as a strict economic boundary. It punishes those who hide their vulnerabilities, and it protects businesses from taking on risks they could not possibly predict. We can see how this rule evolved by looking at a mid-20th century laundry facility, much like the one in the 1949 Victoria laundry case. A manufacturer delivered a commercial boiler 20 weeks late. Because of the delay, the laundry lost its ordinary daily profits, plus several highly lucrative, secret government dyeing contracts. As documented in this academic journal, the court refined the Hadley standard. The laundry successfully recovered its ordinary profits, but the secret government contracts were deemed too remote because the laundry never communicated them to the boiler manufacturer. In 2008, the Achilles case brought the rule into a sprawling, hyper-volatile modern shipping market like the one shown here. A chartered vessel was returned 9 days late, causing the owners to lose a $1.3 million follow-on contract. Lord Hoffman introduced the assumption of responsibility test. The modern standard goes a step further. Even if a massive financial loss is technically foreseeable, the law now dictates that you are only liable if you objectively assumed responsibility for that specific type of market risk. A modern commercial contract is not a magicless shield against all harm. It is a highly calibrated instrument used to allocate mutual risk. As these two silhouettes shaking hands illustrate, The law of remoteness forces business partners to look each other in the eye and disclose their unique financial risks before they sign on the dotted line. Hadley versus Baxendale proved that keeping commerce moving requires honest communication. Justice demands that we keep our promises, but it also dictates we fully comprehend the weight of what we are promising.